initial award of the exploration right, because I haven't set aside that award. If the renewal is refused, that's the end of it, as you said, Justice Colopin. If it's granted, then it's a valid grant, because it's now pursuant to this particular order, which is going to do this. It'll be a valid grant. So you've got that anomaly, that because of these particular circumstances and the particular solution which the court fashioned, you have a valid renewal, or potentially valid renewal, in circumstances where the initial award was declared unlawful but not set aside.
But the initial award was set aside, but that order was suspended.
Not by the Supreme Court of Appeal.
Well, the Supreme Court of Appeal endorsed the High Court's findings, not so, but it simply suspended the reviewing and setting aside, not so.
So I'm suggesting that that suspension is not really, although it's taken from Section 172 itself and from the cases relied upon, the effect of this is really that the setting aside of the grant of the initial order is then ceases to be effective upon the grant of the renewal, because that's the effect of the order of the Supreme Court of Appeal. I know the logical conundrum that's been set up by the use of the word suspension until an event, and then if it's not suspended, then it's actually set aside. But to get round that and to get to the core of what was intended, to interpret this purposively, well, I think that's the only suitable outcome.
Okay, I'm not sure I agree with that, but just lastly, Mr. Loxton, you spoke about the SCA in paragraph 31 seeking to craft a consultation process that would cure the shortcomings in the 79 order.
Yes.
And my question simply is that permissible at all? Because, in a sense, can you, in a renewal process, almost seek to look backward and to cure something that has happened there when you're not in the heart of dealing with the 79 application but the 81 application? And it's almost by impermissibly extending what happens within the 81 renewal application that you try and cure what went wrong in 79. I'm just saying it might be a field day for admin justice and other lawyers if we go this path.
Justice Colopin, when you have a look at some of the orders which have declared administrative action unlawful but then not set it aside and allowed it to continue, they're in exactly the same position. They're permitting and giving legal force to an unlawful administrative act for a particular purpose. And that is, if you go back to Bengwenyama and you go back to the cases to which it refers, it's the solution to the anomaly that says you can have an unlawful act. Odekral, it's lawful until set aside. But even beyond Odekral, even if it's declared unlawful, the court may decide not to set it aside and may decide to give legal effect to an administrative act determined to be unlawful because of an overriding desire to give a just result to that problem.
Mr. Loxton, on that point, it seems to me that one would need to answer Mr. Nqukatobi's complaint that what the essence of that is that you'd have an administrator making a decision on an extension application that would trump an order of the High Court that remained, now that the suspension is affected in a sense, it would trump the order of the High Court which said that this decision is reviewed and set aside. So that the suspension arises only in respect of only to allow the third renewal to be considered. Once that decision is made, let's say favorably for your clients, then you have a decision of an administrator which stands, but an order of the High Court which says that the initial exploration right and the first two renewals are in fact unlawful. And you're saying we must read into the Supreme Court of Appeal order that what was intended was that in the suspension, that if it were to be that the third renewal were granted, that what the Supreme Court of Appeal intended was that the decision of the High Court in respect of the first three decisions would be set aside.
Yes, so in order to give effect to the decision of the Supreme Court of Appeal, you can't read the order as being that as soon as the application for renewal is granted, the renewal is void. The intention has got to have been, if you meet my requirements and the requirements of 81, the renewal then will be valid. So this is not a case where an administrator is renewing an application in the face of a High Court order saying that it's void. What the administrator will be doing is saying, I have read the decision of the Supreme Court of Appeal. I see what they've said. The Supreme Court of Appeal cannot have meant that I must entertain the renewal application, but then refuse it because it's void. So that simply would be inconsistent with the purpose of that order.
But at least can we not agree that it's sufficiently vague to warrant, even if we were with you on that point, interference from this court with the terms of that order?
There is no doubt that this could have been phrased better, that it doesn't reflect the kind of nuances that may have been included in the order had that court considered the issues which are now being raised. So I must concede that there is room for improvement of that order. So our submission to this court would be, we cannot have an objection to this court saying, we see that there are defects in the nature of the order that you've made, and we're going to retain the object of the order, but we're going to replace it with something more structured.
Question relates to why the underlying right, what is your objection to having the matter referred back to the administrator from the outset? Why must it be that in a consideration of what would be a just and equitable remedy, be that initial exploration right is retained and protected?
There were problems with that. 3, the fundamental purpose of corrective action by this court under Padja would be, and usually you would say, you've got that wrong, that wrong, and that wrong, get it right, and then you may grant the right or whatever it is. There would be no point in saying to the administrator, do it all again, even the things we say you got right. So think of, you'd have seen a fraction of the documentation, materials and reports which actually were developed for the purposes of the initial application. It contains an enormous amount of work which is not under challenge. So the first problem is to send it back and say, do it again, means that you're going to be redoing and reconsidering things to which there's no objection. The second is the moratorium. So if the moratorium is valid, and there's no reason to believe that isn't valid, then unless there's an interpretation which no one has suggested yet, that this escapes the moratorium, and that the minister who has issued the moratorium says, despite the fact that the renewals are set aside and the grant is set aside, I can entertain a new application, because this would be a new application by somebody, despite the moratorium. I haven't seen any suggestion from the appellants that that is a possibility. So every road that the appellants take lead to a dead end.
I didn't understand when I'd raised that point with Mr. Nkaitobi, that that was necessarily a dead end. Is that it could feasibly be so that a court order would say that this is sent back to the beginning. You're sent back to the starting blocks. And on the unique facts of this matter, those starting blocks are the status quo that applied at the time that you made your first application for an exploration right. And that might mean then, by extension of that reasoning, that you would then be outside of a moratorium period, and you'd be able to then apply for the right at that stage. That would be my first issue that I'd like to raise with you. The second one, which I might as well put right now, is that in relation to your other view on that lots of the background work that's done on the application, in fact, is not under challenge. Well, it's difficult to determine that, is it not, if there hasn't been thorough and proper consultation? Because if there hasn't been thorough and proper consultation as required by the Act, then how do we necessarily conclude that some of the other material you would have put up in that initial application wouldn't have been subject to challenge?
Well, Justice Savage, you can be guided by the very detailed attack on everything that has been done in this matter by the appellants, who have been very diligent in the case that they have mounted. I doubt whether any stone has been left unturned.
Point on the moratorium?
So the difficulty with the moratorium is this, is that you would then be doing something very similar to the Supreme Court of Appeal, because you'd be saying, although there's a moratorium, we're going to give an order which assumes that you will not be subject to the moratorium, although you are subject to the moratorium, and it is an administrative act which hasn't been set aside, so we're going to avoid that. And then you'll have to say something about what law applies. Because I think learned friend Mr. Ferreira raised that flag. He said, well, if you send it back, maybe Mr. Nkaitubi, if you send it back, what legal regime is there? The legal regime which applied when the application was first made, is it what applies right to this moment? It's difficult. It's not an easy option either way.
Thank you.
Mr. Loxton, just on the question as to what the Minister could do in the context of a third renewal with the information that is elicited from a further consultation process, I would remain concerned that Section 81 on the face of it limits the factors that the Minister can take into account in deciding whether to grant or refuse a renewal. So there might be consultation raising a host of facts, but only some of them may bear on the matters that are relevant to the renewal. Can I just read you a formulation which is not necessarily precise, but which might... I was trying to work out how one might get around this, assuming a very wide exercise of the Court's powers under Section 172. The Minister shall refuse the third renewal if on the same information he would have refused to grant an exploration right.
So that's a very elegant, with respect, formulation of something that we've been trying to get to in drafts which we've exchanged, which is almost exactly that. He must refuse it if...
On everything that is elicited, he would have refused the exploration right.
If it were...
Because I don't think on the frame of Section 81 at the moment he would have that power. I think he would need to be given it by the Court.
I acknowledge that.
And then there's the question, well, is that the better, assuming there's any assistance to the present respondents. Is that the better route, or is it better to send it back to the beginning? What strikes me that if, for example, it went back to the beginning and there was a carve-out of the moratorium which then didn't apply, for all I know, Shell might be better off with that, because then if it got the exploration right, it would have 3 more renewals, whereas at the moment it's only got 1 more renewal. So that would have to enter into it. If everything was set aside and it went back to the beginning and you eventually got the exploration right, then under the statute you would have the opportunity to seek 3 further renewals.
There's one further problem with sending it back, and that is that we will not necessarily be first in line, because if the application has to start de novo,
right, then
there may be somebody else.
Yes.
And since we've had to publish the exploration results, there may well be somebody else.
Thank you.
I propose a 30-minute lunch adjournment in keeping with our earlier undertaking to try and finalize things today, if you still are amenable to that arrangement. All right. We'll come back at 25 to 3.
As it pleases you, Chief Justice.
For a chance. Mr. Loxton? You still have questions for him? There are still questions for you, Mr. Loxton.
We had a quick discussion, and we all thought that I was off the hook.
Just 1 minute, please, Mr. Lux. I'm just calling up my notes. Impact raised the question of the moratorium for the first time at the hearing at the Supreme Court of Appeal. Was it permissible for the Supreme Court of Appeal to take that factor into account when considering an appropriate remedy? And that was also not before the High Court. Would the Supreme Court of Appeal not have been bound by the record?
So as we pointed out in the heads, the moratorium was published in the Government Gazette, so that was in fact available to everybody. That didn't have to be part of the record because both courts could take judicial cognizance of what was published.
That's your answer, Mr. Loxton. It was not raised by impact at the High Court hearing, raised for the first time at the Supreme Court of Appeal in response, if I recall correctly, to directions from the court.
Yes, so the question of the moratorium was raised and debated. Well, it was raised in response to that request, and then, of course, was known to everybody who argued that Supreme Court of Appeal matter. But I don't know to what extent I can call on extra curial knowledge, but in any mining textbook, Dale et al., any mining lawyer, the moratorium was notorious because of its effect. So it was well known.
It was not brought to the attention of the judge presiding in the High Court.
No. I wasn't there,
Yeah.
but from what I read, it was not discussed or brought to their attention.
Yes. If we look at the order that was made by the Supreme Court of Appeal, unfortunately, I don't have the record number. I just have an electronic version.
20.
I know it's paragraph 32. I'm not sure what volume it is in. I'm told it's volume 22.
Yes.
Paragraph 32.
Yes.
Order. Part B of the order says paragraphs 1, 2, and 3 are suspended. Does that mean the declaration of invalidity is suspended?
Judging from the findings made by the learned judge, what is suspended seems to me to be the setting aside of the award.
The setting aside of the?
Of the grant of the right.
Now, if we look at paragraph 31, just above that, the fifth line, it says, in terms of section 81.5 of the MPRTA, an exploration right in respect of which an application for renewal has been lodged shall, notwithstanding its expiry date, remain in force until such time as the application has been granted or refused. Now, that is a correct statement in law. But it doesn't take into account that the exploration right was in fact set aside.
Sorry, I didn't catch that last.
I said, the reasoning of the judgment does not take into account the fact that the exploration right was in fact set aside by a court.
Yes, so
You see, it goes on to say, thus, despite the current expiration date of 26 August 2023, that can't be right.
no, you've got to read that statement in the light of the direction that we got from the Supreme Court of Appeal, which was to say, given that that your current right expired on this date and it's already come and gone, is this appeal not moot because you've got no right left? So we then said, no, it's not moot for the purposes of this appeal because there was an application for renewal. But that's obviously based on the fact that it was...
Where's that dealt with in the judgment?
That's not dealt with at all. But you'll see, if you have a look at the preceding lines, where it says let me start with it. He sets out the email that we got, the direction. Inasmuch as each of the first and second renewal of the right, which was issued on the 20th of December, 26 August, was not to exceed 5 years, the parties will be required at the hearing of the matter to address whether the decision sought on appeal will have any practical effect or result within the meaning of section 16.2.1. Now, that's why this discussion took place. Obviously, if the Supreme Court of Appeal had not suspended the setting aside of that grant, of the renewals and that grant, then it would have been academic, because then there would be no right whether or not it expired. So this was only relevant in the context of, was the appeal moot?
See, that does not appear from paragraph 31. Does not appear from paragraph 31 that that court was of the view, because of the renewal application, that the exploration right was still in existence.
So I think we reverse the order with respect. They were dealing with mootness, and so it's validity in the context of mootness. So it would have been moot for the purposes of the appeal if there'd been no application for renewal. When this court then says we're going to suspend the paragraphs 1, 2, and 3 of the order of the High Court, that effect is that renewal is then valid, because if you look at the rest of 31, he's saying go and have these consultations in order to support your renewal application.
Can a renewal application stand where the grant of the original right has been set aside?
No, and that's why it's important that the setting aside is suspended. But for the suspension, there would be no extant right.
The application for the renewal was made in July 2023. The judgment of the Supreme Court of Appeal was handed down on 3 June 2024. The High Court judgment setting aside the grant of the right was made in September 2022. So what do we say about the effect of the order of the High Court in September 2022?
if the order had not been suspended,
Let's not go to the SCA yet. Let's just
No,
talk about 20.
if you leave aside the suspension, then the effect of that is there's no right.
So how can there be an application for a renewal of a non-existing right?
Because the application is brought and then it's logged. So there's no action taken on the application, but it's brought. The fact that you bring an application then prolongs the expiry date. But again, had it stopped at the High Court, the right would have then come to an end because of a setting aside of the renewals and the original right, the original grant.
Now, if we look at paragraph 31 again of the judgment of the Supreme Court of Appeal, what are the meaning of those words? It says, notwithstanding its expiry date, shall remain in force.
So
Does that mean that even after the period for which the original right was granted has expired? Is that what it means? Is that correct?
the section, exactly. So, and why the section is there, it says, if you apply before the expiry of a right for its renewal, the fact that before the renewal is granted, the original period expires doesn't mean that the right expires. That's what that section says.
Paragraph 1 does not say, paragraph 31 of the judgment does not say, an exploration right in respect of which an application for renewal has been lodged during the existence of the right. It says, notwithstanding its expiry date. Doesn't that imply that that application could be made for renewal according to paragraph 31? I see you shaking your head in disagreement. Isn't that what paragraph 31 implies? That as long as the application is made, notwithstanding when it expires, what does that mean? It doesn't say as long as the application is made during the existence of the right.
Justice Turon, if you read the response to the email which is reflected...
I don't want to look at emails.
No, but,
I want to look at the judgment and understand what the
but you
judgment
understand what the learned judge is saying. You've got to realize...
We look at judgments, we don't look at emails to try and understand.
Sometimes
to
emails
get the
are
meaning
not
of the judgment.
Justice Turon, all I can say is that because of the response to the request about mootness and the explanation that it wasn't moot because an application for renewal had been made during the currency of the right, it therefore didn't expire. That's why when he sets out at lines 9 to 13, the question, inasmuch as each first and second renewal, which was issued on 23rd respectively, was not to exceed 2 years, the parties are required therein to address whether the decision will have any effect. Now, the reason he's asking that is that when you look at the rights, they have expired in accordance with their terms. But because of the section which prolongs the period, they haven't expired. So it's purely in explanation of the mootness point.
Now, I'd like to explore an area that Justice Savage explored with you, Mr. Loxton, and the powers of the minister in terms of a renewal application is prescribed in section 81.3.
Yes.
Can this court, in the exercise of its powers to grant just and equitable relief, add additional factors to those listed in 81.3 for the minister to consider? Would that not be a breach of the separation of powers doctrine, because this court would then, in effect, be making legislation?
Justice Theron, that is often the outcome of orders like this. So if I take the basic, where you have a tender which is accepted unlawfully, you have a panel of attorneys, they are unlawfully there. The law will say to you, this regulation's been breached, and therefore this board is unlawfully constituted. The court says, I know it's unlawfully constituted, but I'm going to...
That's something else. We're not on the same page. Or as my child would say, we're not on the same WhatsApp group. We're not talking now.
Excuse me one minute.
Yes.
I'm going to retrieve a bottle of water.
Not talking about the power of the court to suspend the declaration. In terms of Section 81.3, there's a closed list of factors that the minister must take into account when considering a renewal application. If this court was to add to those factors, it would be making legislation. And my question is, see, the concern of the applicants is that this process, the renewal process, does not vindicate their rights of participation. If this court was to add to those factors in Section 81.3, and I think in my question to Mr. Ferreira and I think to Mr. Ngugaitobi as well, I asked if the court was to say Section 79.4 would apply, would the court not be overstepping? Would the court be imposing obligations on the minister that's not imposed on him in terms of the enabling legislation?
Justice Theron, if you were not exercising your powers under 172, you would not be able to say to the minister, I want you to take into account factors which are not encompassed in the Act, because that would be legislation. But if you're exercising powers under 172, and you're doing it in order to address this particular problem, where the setting aside of a particular administrative act would have dire consequences, then in that process of exercising that power, you can require the minister, as the court did here, to, for example, consider the outcome of consultations. You can require...
My concern, I don't mean to interrupt you, but I can see where you're going, Mr. Loxton. My concern with that is this assumption that under 172 and in determining a just and equitable remedy, this court can do almost anything. But that's not correct. The court must only do or can do the powers that are prescribed to it. The court cannot order under that section that something that's illegal that should be done. Did you understand? If the legislation doesn't permit something to happen, how can this court under 172 say, well, we're going to order that must happen?
Well, let me put it slightly differently. If your ladyship's concern is that this court can never, under 172, give legal effect to something which is unlawful, declared to be unlawful, then there are many examples where this court does exactly that.
I think you're going too broad, Mr. Loxton, and I've been a judge for a few years, and we do have the power in certain circumstances. But my specific question to you is, does this court have the power to order the minister to do what the enabling legislation does not empower or order him to do?
This court didn't just say, I want you under 81 to...
Can you answer my question directly, please, Mr.
So that is, it has the power to fashion a remedy which would require the minister to do something not required to do under 81.
And if in fashioning that remedy, this court oversteps the boundaries of separation of powers, would that be acceptable?
My submission to you, Justice Theron, would be that you're not overstepping the boundaries,
Answer my
acting
question,
precisely
please, Mr.
within
Loxton.
the remit of 172.
Hypothetically, if this court oversteps the boundaries in ordering the minister to do what he does, the enabling section does not allow him to do, would the court be overstepping boundaries of separation of power?
If it is necessary to give effect to 172, that you order a minister to do something which he's not empowered to do, you would still be acting within the bounds of your power. And there are many examples of that, where, for example, somebody is employed where he shouldn't be employed. The minister is effectively asked, as the employer, to assume that a person met criteria when he didn't. In other words, you'd say, accept this person who does not meet these requirements, because that's the just and equitable remedy in this situation. So
That amounts to a suspension. So the person may have been appointed in a process that wasn't valid, wasn't a valid appointment. So the suspension order then suspends that declaration of invalidity. We're talking about something very, very different.
But if the minister is ordered to do something which amounts to more than a suspension, the minister is ordered to take on, to employ, to take back a person who doesn't qualify under the regulations. You're asking the minister to do something which the statute does not require him to do, because you're doing it under 172.
Yes, thank
And
you.
that's common.
Thank you, Mr. Loxton. Thank you, Chief Justice.
Mr. Loxton, just one question from my side. It's also in relation to the same paragraph that you traversed with my sister. At the foot of paragraph 31, the SCA alludes to the fact that a 19-volume record would assist with the determination of the matter. But we know that that 19-volume record is bereft of the views and the comments of the community. Now, why place before the decision maker a record that on the face of it appears to be deficient?
Justice Matopa, because it's the record which demonstrates the deficiency. So what you've got is a record which demonstrates that there was no publication of the notice in isiXhosa. You've got the record which shows that there's then a complaint about that very issue, and then you've got a judgment which says because of that there's been a failure to comply with the Act and the regulations. So as I understand what the learned judge was saying is that when you read that, you'll identify what the problem was. You were supposed to communicate, you didn't communicate, there was a complaint about the communication, so the absence of communication is a defect which appears from the record. I think that's what the learned judge was saying.
But it's troubling for me because right in the preceding paragraph, the SCA talks about the imperfections in seal, and it says those imperfections will be cured. But that's a lot. Do you appreciate that's a lot that the decision maker is asked to consider?
And the burden is on the respondents and the decision makers. So effectively, to give effect to this order, when we decide to rerun those consultations and rerun the application that we're now being asked to do, we would have to look at everything, and we'd have to say, what are the things that are wrong? What are the things we've got to cure? And we better be very conservative, because we don't want to find that we're back in court being reviewed because, in fact, we didn't cure the problem. So it is a burden, and it's a burden that falls, though, on the respondents in this case.
Well, hypothetically, if the moratorium was not standing in the way of Shell and Impact, do you think the order that the SCA has granted would have been granted? I look at it as some form of legal engineering of some sort to try and accommodate a party that, from a word go, it has a problem.
I would imagine that, well, all I can say is that, but for the moratorium, the SCA may well have come to a different conclusion. I can't say what that is, but I can say that it played a significant role.
You see, my problem is the SCA definitively and explicitly made it clear that the foundational requirements were not met. And in a sense, 90 or 100%, it endorsed the judgment of the High Court. Right? And when it was told about the other factors that militated against the setting aside or going to the default position, it's, oh no, well, let's look at what Shell and Impact have put forward. If we are to give an order of a setting aside, it will be out of pocket. And the consequences, or the economic consequences, probably on the part of the SCA, would be too drastic. To try and ameliorate the position, it says, let's go back and say, have the public participation. But is that approach correct? It worries me. Perhaps you can allay my fears and my worries.
That seems to us to be the very kind of process which a court will undertake when faced with a problem of an unlawful act, which, if set aside, will have very far-reaching consequences for people who are not guilty of anything in particular. And so what 172 does, and what the courts say that it does, is that you then say, how do I ameliorate this? Well, one of the ways, and it's explicitly in 172, is that I can suspend a decision. Or, in fact, I can treat a decision as being not set aside, although unlawful, and you can continue to finish the project or whatever it is. So it's very much along those lines that this court operates. I recognize that any attempt by a court to act under 172, because it's trying to strike a balance between legality on the one hand and a just result on the other, there will be compromises. So that's why the fact that an act is unlawful does not mean that it has no effect. And that's at the heart of what the court is doing. It's at the heart of 172. Not every unlawful fact is without consequence.
Do you recognize that when one reads the judgment of the SCA, there is no proper or meaningful engagement with the remedy that it had proposed, the Section 18.1? Nothing. It said only in one line, which my sister has just traversed it with you.
The,
If you read the judgment, and let's put it this way, if the applicant's attorneys and their counsel were to explain to their clients what happened, and looking at the judgment of the SCA, what are they going to tell them? Because the judgment as it is, it does not engage with the issues. It does not tell them or us why suddenly we decided that we're suspending prayer 1, 2, 3 and imposing a suspension order. Where is it being dealt with? Except in the few lines that I've seen.
so what the judgment does is set out the facts that it took into account. Those facts are on the record, so none of those facts are introduced at some later stage. They're all there. And he says, because of those facts, this is the remedy I've crafted. It could have been more explicitly fleshed out. It could have been better fleshed out. But the fundamentals are there. It's unlawful, but these are the consequences. Those are the facts I rely on, and therefore I am suspending the order of the setting aside. And so it might be rather brief, but it is there.
Well, at a practical level, if one were to go back to where this matter first started, you have an application for this ER, which ought to have followed certain legal prescripts. And we know that there was no proper or adequate, let's say adequate, let's not use proper, adequate consultation. And the closest that the impact and the respondents come to is that we spoke to the chiefs, we spoke to a gentleman called Zakululu, and thought Zakululu would relay the information and the messages to the community. And nothing was. And community says, suddenly we see these huge operations in our area. We then ask the question, what is happening? We are told that a permit has been granted. And community goes to its attorneys to say, what is happening? We don't know anything about it. And community goes to the High Court. High Court agrees with them. Nothing wrong with that so far. And both parties are at idem that at a common cost level, yes, there was no proper or adequate engagement, even though your clients seem to suggest that they ought to have known, and they've put in those adverts in Afrikaans and English newspapers, which did not do anything. And on the part of the applicants, instructing the attorneys to go to court, they get an order that says there was no proper or adequate engagement. They are content with that. It's set aside. There's an appeal before the SCA. SCA decides that we want to suspend the operation of the order. It doesn't talk to them. How can the applicant, legal representatives, explain to their client to say, suddenly it was a lucky packet thing. We don't know what we'll get. We opened lucky packet, boom, the suspension order is here.
Justice Matopa, can I take it back a little bit?
Please do.
In the High Court, Impact said you shouldn't set this aside. Mm-hmm. It's not just or equitable that you should set it aside. They say that in the affidavits, they say it in the argument. When we get to the Supreme Court of Appeal, we repeat the argument. You shouldn't set this aside. We don't specifically say, and instead instead of changing the order of the court below by simply saying, and I don't set it aside, what the SCA does is to then say, I suspend it. So although we don't ever ask for that specific relief, what was clear and was clearly before the SCA is a debate about whether it was just and equitable to set it aside and whether or not the High Court had erred in setting it aside without considering what was just and equitable. So that was the argument in front of the Supreme Court of Appeal. So what couldn't have come as a surprise is that that court might fashion a remedy which did not involve setting it aside, but some other remedy. The other remedy was not, we had not spelled it out, but the fact that whatever had happened in the High Court was not just and equitable, that was clearly before the SCA. It was clearly before the High Court. The High Court did not address it at all. That's why we were able to go to the SCA to say, intervene in this, because the High Court didn't exercise the discretion. We're not asking you to interfere with the true discretion. We're asking you to exercise a discretion which the High Court didn't. So that's the context.
Okay, thank you.
Thank you. This time I am off the hook.
You are. Is it Mr. Friedman next?
May it please you, Chief Justice and Justices. Where I want to start, if I may, is just to focus on what both my learned friends for the appellants have explained is the scope of the rights that they rely on, especially Mr. Ferreira, but both appellants made it very clear that when it comes to the rights that were acknowledged in the High Court and the SCA judgments, there are two components. It's the right to influence whether the ER should have been granted in the first place, and then it's the right to influence whether there should be mitigation measures. So the point that they emphasize is if the order that the SCA made is incapable of giving them the opportunity to persuade the decision maker not to allow it in the first place, not to grant the ER in the first place, then it's an empty remedy. It doesn't fit the injury that they suffered at first instance. That's effectively the argument. And so in my submission, rather than focusing on the ER itself, it's more helpful, and I'll come back in a moment to explain why, but it's more helpful to focus on the activities that were permitted by the ER. Because that's the substance of the debate that's happened in both the High Court and the SCA, is whether the conduct authorized by the ER should have been authorized. Now, I'm not going to read out the record, but I'll just give a reference. It's not necessary for the court to go there, but just in case anyone needs it, it's page 244 of the record. There are other places too, but that's the easiest place to go. That is a summary of the conduct that was authorized in terms of the ER. That reference I gave is in the EMPR, the Environmental Management Program, but that in substance is what supports the ER, and that's what gives the scope of what the activities in the ER were authorized. And one will see when one goes there, it's essentially a 3D seismic survey, but there are other components that go with that, something called sea bottom bathymetry. I'm not sure what that is. It uses a multi-beam eco sounder. Then there's surface heat flow measurements, and then there's a seabed and water column sampling program. So the debate really in the papers was all about the seismic survey, but there were other components as well that were authorized. So in my submission, the way to approach this case is to ask the questions in a slightly different order to the way that they've been dealt with so far. I would respectfully submit that one should ask whether an order along the lines of the SCA order is capable of allowing the appellants the opportunity to persuade the decision maker not to authorize that activity. because that's the substance of what the complaint is. They say we should have had an opportunity at first instance to submit to the minister that you shouldn't authorize these different activities, the survey, the bathymetry, and we didn't get that opportunity. So now the question has to be asked, is an order along the lines of the SCA order capable of achieving their opportunity to persuade the minister not to authorize that conduct? So that's where, with respect, I would start. And then I would say, if the answer is yes, then the question becomes, is there any good reason not to have granted an order such as the SCA granted, bearing in mind that the SCA did exercise a true discretion. Now, of course, that true discretion that the SCA exercised is not a major obstacle to this court. Let's be blunt and frank about it. Justice Taran asked my learned friend for impact multiple questions about the reasoning in the SCA order. There would be multiple opportunities for this court to say that the SCA misdirected itself if that's the way it pans out. But the point is that that is the order that the SCA made. It is a true discretion. And so the question is, if it can achieve the purpose that I've just identified, why shouldn't it be confirmed by this court? And again, the last thing, if I could just say on that point, is there's been a lot of debate about the apparent vagueness of the SCA order and the precise terms of the SCA order, which I completely understand. But I would submit with respect that we should just be careful not to conflate that question with the question of, the prior question of, can the SCA or an order like the SCA's achieve the purpose of allowing the appellants to dissuade the minister to allow the seismic survey to proceed? That's the first question. If the answer to that is yes, but the court then concludes, this court concludes, there are vague elements of the SCA's order, this court has the power to amend the SCA's order. And I'll address that briefly in due course, but I don't think that's controversial. So the point, though, is that the prior question should be, is the order fit for purpose in its principled basis? And if the answer is yes, well, we can then have a debate about whether it needs to be fixed because it's too vague. So on the first question, Justice Matopo asked a question, and I'm not trying to be obsequious, but really this is the main question. This is the main question in my respectful submission. He asked my learned friend, I can't remember which one of the appellants, he asked if the minister refused to renew the ER, would parties such as my clients and Impact, would they be entitled to review the minister's decision? And we can ask that at the more abstract level. One doesn't have to worry about it on the facts of this case. But it's a crucial question. One can ask it like this. If in any, it doesn't have to be tied to this litigation, just in the abstract, just in principle. If in any renewal decision, the minister declined to renew the application because he considered it, for example, inappropriate to conduct a seismic survey, insufficiently cognizant of the rights of the communities in the area, etc., would the aggrieved holders of the right be entitled to review that decision? And the reason why, with respect, that's such an important question is because it touches on a lot of the questions Justice Taran also was asking my learned friend. Our respectful submission is Justice Taran is absolutely right. This court doesn't have the power to overstep what the legislature has said is the law on a particular subject matter such as Section 81. And so we have to persuade the court that the minister would have the power under Section 81 to decline a renewal application if he considered the facts of the case or the circumstances to suggest that it would no longer be appropriate to authorize the conduct that is covered by the ER. Because if we can't persuade the court of that, then Justice Taran's questions come straight into play. And it raises the question of, is the court's power under Section 172(1) so vast that it can, in fact, cut across a choice that the legislature has made? So what I wish to try and persuade the court is that Section 81 can be interpreted to allow the minister to decline to renew the ER if it is inappropriate to allow the activities to carry on, and that therefore, to answer Justice Matopo's question, in a case where the facts in front of the minister suggested that the conduct in question, let's call it a seismic survey just to keep it within the facts of this case, the conduct of a seismic survey is no longer appropriate, and the minister therefore declines the renewal application, there would be no cause of action on review. The aggrieved parties would have no remedy. Of course, they would no doubt try and pursue one, but they would have no prospects of success in a review. Now, the reason I make that submission is we must not lose sight with respect of the fact that we are still engaged in an interpretive exercise here. We have to interpret Section 81.3 or Section 81 as a whole. And this court knows full well the principles of interpretation. I'm not going to waste time on it. There's been multiple cases since the University of Johannesburg decision. All we need to just bear in mind is we know that the context, the text, and the purpose are all taken into account, and they're all equally important. This is trite. But part of that exercise in my submission is also to recognize that there will always be parts, or there may always be parts of a legislative scheme which are unspoken. So, for example, this comes up in the United States all the time. That Supreme Court has been grappling with their constitution for over 100 years in circumstances where there are gaps or where it doesn't speak about something, and then the question has to be, well, what it was intended? What does it actually mean? And it's no answer with respect, and this is in response to certain questions that came from the bench, it's no answer to say, well, Section 81 is very narrow, that's the end of the matter. Because that's an interpretive conclusion itself. That's adopting a very literal textual interpretation of Section 81.3, which maybe the court will do at the end of the day. But it's one mode of interpretation. And in our respectful submission, another or a better interpretation would be to consider various contextual and purposive considerations and ask oneself again, could the minister decline an application if he considers the conduct to be inappropriate? Let's call it again a seismic survey. So the first thing when it comes to the context and the purpose that is important in my respectful submission is the fact that we know that the legislative scheme admits of the possibility that an ER may stay in existence for more than 10 years. We know about it on the facts of this case, of course. This is a strange and unique case, perhaps. But even in a normal case, if one takes into account the fact that an ER lasts for 3 years, and then there may be 3 subsequent renewals of 2 years each, we get close to 10 years, even if every single time the application was made, it was granted immediately. And I just pause for a moment because this comes to part of what Justice Taron was asking my learned friend about the SCA judgment. We have to remember what Section 81.5 says. It says as soon as you put in the application, effectively time is frozen. So in other words, you have 2 years for your renewal period, but if you put in an application, the clock doesn't start ticking until that application is decided. And we know from the facts of this case that the minister sometimes takes quite a long time to decide renewal applications. So we now can see why, just on the legislative scheme, it can be more than 10 years that an ER remains in place. That's the first part of the context, and I'll come back to explain the relevance to it in a moment. The second part of the context that I wish to refer to is Section 2 of NEMA. Section 2 of NEMA sets out the principles which shall apply, I'm just reading what it says, alongside all other appropriate and relevant considerations, including the state's responsibility to respect, protect, promote, and fulfill the rights in the Bill of Rights, and they serve as guidelines by reference to which any organ of state must exercise any function when taking a decision. It must exercise any function when taking any decision in terms of this Act. And then Section 37 expressly says that when it comes to prospecting and mining operations, the NEMA principles apply, and I don't want to waste my time, but if the court just bears with me and takes my word for it, I'm sure the clerks will check me. The definition section in Section 37 means that exploration is covered by this as well. So it applies to exploration rights as well. And then if one looks at those principles, one of them is negative impacts on the environment and on people's environmental rights must be anticipated and protected, and where they cannot be altogether prevented are minimized and remedied. And then another one is, decisions must take into account the interests, needs, and values of all interested and affected parties, and this includes recognizing all forms of knowledge, including traditional and ordinary knowledge. So, I would submit that if one takes into account the NEMA principles, and then one takes into account the fact that exploration rights can stay in force for more than 10 years, we start seeing the context in which the Section 81 power needs to be exercised. The last part of the context that I want to mention before I pull it together is Section 24Q of NEMA. That provision says, that provision imposes a duty on all holders of environmental rights to conduct monitoring to assess the continued appropriateness and adequacy of the EMPR. So it uses both words, appropriateness and adequacy. If the only issue was adequacy, then it wouldn't have said appropriateness, and then what would be the only issue in play would be the mitigation measures. That's what's covered by adequacy. But the fact that Section 24Q itself envisages that there should be ongoing assessment of appropriateness is another factor in my submission that one should take into account when one is looking at the context. So, we now pull all of that together. And I now ask you to postulate a hypothetical scenario. It doesn't have to be related to this litigation. But we have a situation where an environmental right was granted more than 10 years ago. The applicant comes before the minister and puts up information in order to substantiate the third renewal application. The minister sees from that information or from other information, and I'll come back to how that can be derived in a moment, he sees that there are multiple problems with the authorization of this particular conduct. Let's say, for example, in the 10 years since the right was granted, there have been lots of scientific developments, and now the question of whether the right should have been granted has been opened up by all of this new scientific development. In the context of those NEMA principles that I mentioned, and also the Section 24Q, we have to ask ourselves, would the minister be obliged to renew the right? Because that's the implication of the questions that came to my learned friend. The premise of the doubt that the judges who asked those questions, the premise from which they're operating is Section 81.3 does not allow the minister to take that into account. And if that is true, then my learned friends are correct, that it's an inappropriate remedy to make everything done in the renewal process. But my submission is if one takes into account that context, the minister would have to be entitled to say, look, this right was granted 10 years ago. Whatever may have motivated my predecessor to grant it 10 years ago, on the information in front of me, I can't renew it. Because if I renew it, I will be authorizing activity which is no longer permissible when one takes into account the NEMA principles, when one takes into account Section 24 of the Constitution, when one takes into account Section 24Q of NEMA. So, my submission is that, in principle, the minister would be entitled to refuse an application. If that is the case, then there is no legality problem with an order such as the SCA's order. There may be a vagueness problem, but that's a different question. If this court is concerned about vagueness, then this court can panel beat the order and it can impose a scheme of consultation that is much more precise than what comes out of the SCA order. We have said in our affidavit in this court, we have supported the SCA judgment and order on the basis that we've said, and it's a point my learned friend Mr. Loxton made just at the end as well, it's the respondents who bear the risk. So if the respondents don't take effort to make sure that the appellants and everybody who has a right to be consulted are properly consulted, and the renewal application is granted, well then it will be immediately subject to review. And if they don't take that effort and it's refused justifiably, well then they won't have a cause of action to complain. But if the court is not happy with leaving the order in the terms that it was made, the simple solution with respect is simply to change the terms of the order. And with respect, I don't understand why some of the submissions or parts of what we've heard today seem to create doubt about whether this court has the power to do that. I accept with respect entirely that this court does not have the power to go further than what the legislation allows. But it certainly has the power under Section 172(1)(b) to change the terms of the SCA order if it thinks that the idea is right, but the execution of the idea was perhaps not ideal. So this is my first time ever arguing in this court when the buzzer system has been in place, and I can see I'm woefully not doing it properly because I'm going to run out of time. So I'm going to move now on to the question of why shouldn't an order along those lines be granted? And I just want to very briefly say something about the context. My learned friend, Mr. Ferreira, especially, placed great emphasis on what he said was the failure to plead the suspension that was granted. And originally, I was indignant when I heard him and make these arguments because I thought, how can they say that? We've dealt with it in our answering affidavit in this court. But as the argument evolved, I realized that in fairness, what they're saying is the facts were there, but there was no argument in the High Court papers that there should be the type of order that the SCA made. I don't want to waste my time. I just want to ask the court to look at my heads of argument. There's no merit in this point that they make that they didn't get a hearing in the SCA. That part's wrong with respect. They did get a hearing in the SCA. Mr. Ferreira's heads in the SCA, for more than 3 pages, dealt precisely with whether the SCA order would be just and equitable. And I've given the references in the heads, and in our answering affidavit in this court, we've annexed his heads from the SCA. So the court can see that I'm correct when I say that. So in the SCA, with respect to him, they did get a hearing, but it is true that the High Court papers did not go into detail on the order that the SCA made. All I want to say to this court, and ask this court to bear in mind, is the context. All of the papers filed by my clients in this matter were complete by the 1st of April, 2022. The court will pick that up in the record. I'll just quickly give a reference. If one goes to page 2037, one will see that Shell's answering affidavit was signed on the 1st of April. And if one goes to page 1722, one will see that Impacts was also signed on the 1st of April. So that was 3 months after Justice Blum granted the interim interdict preventing the seismic survey going ahead. That was on the 28th of December 2021. So the last word that my clients had on the record in this matter was 3 months after the seismic survey was going to go ahead, and at a time when there was no pending renewal applications. So I accept that it was not something which was strenuously suggested in the answering affidavit when it comes to remedy. But there can be no doubt, and this court will look at the papers in its own time, there can be no doubt when one looks at the answering affidavits of both parties. The whole focus there was how there's been investment made, there's been a lot of sunk costs in this project, and that it would not be fair for the Impact and Shell to lose the opportunity to conduct the seismic survey. That is the theme that runs throughout both answering affidavits. It is true it was not framed in the terms that the SCA granted, but with respect, that's because it was 2 years before the SCA made its order, and things had changed by then. And that was not through any fault of Impact or Shell. It was simply because, as everyone has noticed from the questions, the right would have expired if there hadn't been an application for renewal. But I just asked the court to keep that context in mind. Then just this thing about question of Bengwenyama, because that's also relevant to this question of justice and equitability, and I will try and tie it all together in a moment. But there was a lot of debate about whether Bengwenyama is on all fours or whether it's not. My learned friends for the appellants say that it is on all fours with this case because they say that Impact should have known or did know that the communities were affected. And of course we argue differently. I just want to refer to a factual matter. My learned friends referred to page 2690 of the record. And my learned friend, Mr. Toybi, it was I can't remember, one of my learned friends repeatedly said that Impact knew that the communities were not represented by the monarchs or by the traditional leaders, and therefore they can't ask for relief now. I think Mr. Ferreira said they can't ask this court to dig them out of that hole. I can't remember the words he used. But The page is 2,690, and that is part of the record of consultation that took place. And my learned friends referred to that page because at the bottom of that page it says it was highlighted that the sea is part of their ancestral heritage and it is used and accepted as such by the people of Transkei. And so the argument was that it was already made clear at that stage what the community interests were. But I just want to take the court to page 2691. Because at the top there, it says, it was reiterated that the kings and their traditional councils were the correct structures to work through as representatives of the people. They want to promote the local people and their possible role in the project in the future. Now, I'm not trying to justify the consultation with the traditional monarchs. The Shell has made very clear in its papers in this court and in its heads in this court that it accepts the SCA and the High Court findings on the merits and that it accepts that there should have been consultation. I'm dealing with a separate point. I'm dealing with the question of whether they should have been blamed for this, whether they should have known the interests involved. And I would just ask this court, and that's why I mentioned the context earlier, I must ask this court to bear in mind that there was full compliance, and this is common cause on the papers. There's a debate about a notice in the entrance hall of Passer's office, but it's common cause on the papers that there was full compliance with the regulations that were in force at time when it comes to consultation requirements. This English and Afrikaans newspaper debate, the SCA was scathing about the use of English and Afrikaans newspapers. I accept with respect that publishing in English and Afrikaans newspapers clearly was not adequate to give notice to the appellants, especially the community appellants and the people that they represent. But at the time when the consultation took place, there was full compliance with the regulatory framework that was in force at the time. And Impact and Shell say in their affidavits that they relied on the environmental assessment practitioner to guide them through the process that had to be followed. And this court will know from the regulations made under NEMA, an environmental assessment practitioner has a special status when it comes to these type of rights and has a role that is supposed to facilitate an independent assessment of all of the requirements, including consultation. So Impact and Shell relied on that advice and they acted on it. And the only point that we seek to make is that this case is distinguishable from Bengwenyama because in Bengwenyama, the point that this court made in sections paragraphs 87 to 89 was that there was an interim interdict in force at the time that the respondents incurred all of their expenditure. So this court said, you knew that there was an interim interdict in force. It had been granted at the behest of the community. The community said, we want to exercise a preferent right. They brought an interdict application and they were granted an interdict, but then you still incurred expenditure after that. Well, that's on you. That's at your risk. All I'm trying to say is this is a different situation. Impact and Shell in good faith incurred that expenditure and then they after the fact, found out that compliance with Regulation 3 of the MPRDA regulations was, according to the SCA and the High Court, not sufficient. So then it brings me back, and it's a terrible feeling seeing that those things tick down, and you know how much more you want to say, but I'll just try and wind it up and say this. Once one accepts the point that I just made, once one accepts how distinguishable that this was from Bengwenyama, and once one accepts that there is no default position to just simply set aside rights in this situation. In fact, in our heads of argument, which I ask this court to have regard to because those really set this out in a lot more detail, we point out that certainly in administrative reviews, the default position is remittal, and that the SCA order tries to come as close to remittal as possible in the circumstances of this strange circumstances of this case. But the point is that if one acknowledges all of those, then one has to ask, if it is true, of course if the court's against me on this, that's the end of the matter, but if it is true, if the court is with me, that properly interpreted, Section 81 is wide enough to allow the minister to actually, in the renewal phase, decide, I'm not going to authorize the seismic survey anymore because I've decided that I've heard what the appellants have said and I don't think it's appropriate. And if it's wide enough to allow him to say, yes, I'll allow the seismic survey to carry on, but I'm going to impose mitigation measures that are over and above what are in the current ER, then it's possible in a consultation process for the appellants to get everything that they've asked for and everything that they say are their rights when it comes to what the High Court and the SCA have indicated. And then I would say, if that is so, why wouldn't the court wish to make an order that balances everybody's interests and takes account of the investment that the appellants made? I mean no disrespect to some of the questions and also to my appellant's arguments, but there is a almost dismissive tone sometimes about the R1 billion of expenditure. And I accept that there will be circumstances where the court, and in fact Justice Matopo's premise at the beginning, and I fully respect it, is to say, well, can that trump what the Constitution requires? And of course it can't. But if there is a possibility of crafting an order which says, keep that investment intact and also vindicate the rights of the appellants, what would be the reason not to go ahead and do that? And the only reason I've heard that so far, with respect in substance, is criticisms of the SCA's order being too vague. But again, I reiterate, that's easily fixed. And Justice Rogers' formulation, in my respectful submission, would solve that problem. If the court's with me that Section 81 is wide enough to allow the court to make such an order, Justice Rogers' formulation would be sufficient. And simply to save myself the indignity of letting that buzzer go off, I'll stop there. But those are my submissions.
You wasted a few good minutes extolling your frustrations with that clock on the wall, so you have only yourself to blame.
As the court pleases, Chief Justice.
Questions? Yes. Okay.
Thank you, Chief Justice. Mr. Friedman, I did ask this question, and I would like your views on it. Given that the third renewal application was submitted in July, after the High Court had delivered their judgment, the High Court could not have ordered the suspension of the invalidity pending the renewal application. On what basis could the Supreme Court of Appeal have done that?
Our submission is that we certainly know that there is, and my learned friends accepted this, I think, there's certainly provision for new evidence to be submitted on appeal in certain circumstances. I'm not saying that that's what happened here, but it is possible. So in other words, the premise of your question, Justice Theron, is that generally speaking in an appeal, the appeal court can't go further than what was on the pleadings and what was possible in the High Court, which I accept as far as it goes. But our submission would be that if the circumstances have changed in a dramatic and a material way by the time it comes before the Supreme Court of Appeal or this court, and there is evidence on record to support the relief that is being now sought or being now considered, it is within the scope of this court's powers under 172(1)(b to grant just and equitable relief that's appropriate. Because otherwise...
Were the applicants afforded an opportunity to deal with these with the circumstances that changed dramatically?
Well, what did happen was that the facts were there, and as I've said previously, and I can give you the reference, Justice Theron, in our answering affidavit, we attached, that's the answering affidavit in this court, we attached the extracts of the heads of argument that my learned friend, Mr. Ferreira, put up in the SCA. And I'm not trying to make light, they're very important, because if the court reads them, one will see that in 3 pages that we've annexed there, my learned friend said there exactly what he said here. So in other words, he made all the points that he's made in this court. For example, he made the point, Section 81 is not good enough. Well, he didn't say Section 8, but he said a suspension would not be good enough to protect our rights because the original decision cannot be reopened, which is exactly the same points that he's...
Let me rephrase my question, Mr. Friedman. Were the applicants given an opportunity to place evidence before the court about these changed circumstances or in response to the changed circumstances?
No. No, they weren't. They weren't. And, but my submission on that would be, one has...
But then, on what basis can it be fair then to give an order on changed circumstances when the applicant hasn't had an opportunity to respond to that?
Well, the point, Justice Taran, is that the respondents also did not put up new facts. It was simply the same facts that everybody had been speaking about and relying on from the beginning, which is the investment, the loss of exclusivity, etc. So the point is that there was the case from the outset of of Shell and Impact was, we've spent R1 billion, we shouldn't lose the right.
Let's just go back a minute. My opening question to you was whether the Supreme Court of Appeal was entitled to give a remedy that was not open to the High Court. And then you said yes, because of the changed circumstances. My next question was the applicant allowed to give evidence or put up evidence in response to these changed circumstances?
And I answered no. So if Justice Taran, you want a yes-no answer, then the answer has to be no. I can't mislead the court. If I can expand on why I say that's not a problem, my submission would be...
And then after that you said there were no changed circumstances. Everything was already before the court. So that's why I went back, because I'm slightly confused.
No, with respect, the changed circumstance was the fact that now a renewal application had been made, and that 2 years had passed since the affidavits had been exchanged, and now the SCA had an opportunity to make a remedy that the High Court didn't have. But the factual circumstances hadn't changed because the facts on which the SCA relied in its judgment were the same facts that one will find in the very first answering affidavit that Shell and Impact filed in the Part A application. Because from that stage they were saying, we're relying on our exclusivity, we're relying on our R1 billion investment. So those facts hadn't changed. If, Justice Taran, one could postulate a situation where Shell and Impact filed a new affidavit in the SCA and now relied on facts that weren't in the record, and then the SCA hadn't called for proper submissions on that or proper evidence on that, well, that clearly would be a fundamental failure of justice. But what happened here is that they took facts that were ventilated in the record and they adopted a remedy which was now competent given what had happened in the time since then. And it boils down to what this court considers is, you see, with respect, one cannot, in my respectful submission, separate too easily the nature of the order and the question of the fairness here. Because the SCA obviously considered its order to be fair to all interests. It obviously considered that on the facts before it, the order that it was proposing was a win-win situation. And it obviously reached that conclusion on the 4 considerations it mentions in its judgment. Other than the moratorium, the others were all pleaded. My learned friend, Mr. Loxton, points out the moratorium is in the Government Gazette. One can have a debate about the extent to which it should have been pleaded. But the point is that the SCA obviously thought the appellants would not be prejudiced because all of the facts that they would want to place before the decision maker, they could still place before the decision maker.
Where does it appear from the judgment of the SCA that the appellants would not be prejudiced because all of the facts are already before it?
It doesn't expressly.
On what basis do you make that submission to this court?
Because what they do say in the judgment is that you have to fashion a remedy that's just and equitable. They had already acknowledged that the appellants had a right to be consulted and had their right violated. They now say, well, there's a 4,000-page record in front of us where everybody's made their submissions, and therefore what's just and equitable is allow the minister to take...
The only submission I question whether there's a basis to, Mr. Friedman, is the submission that you make that the Supreme Court of Appeal must have had regard to the fact that the applicants would not suffer prejudice.
They had to have.
And I'm saying that does not appear from the judgment of the SCA, that the SCA had regard when it made its order to possible prejudice that could be suffered by the applicants.
Justice Turan, in my submission, from our perspective, there's no... let me make the submission in two parts. In my submission, if one reads the entire judgment of the SCA, that is the necessary inference to draw based on what the SCA said previously in the judgment about consultation about the rights of the appellants. I accept, though, that one has to interpret the judgment in that way, and it's certainly not express. So one can certainly conclude that this SCA judgment does not spell out its reasoning about those issues clearly. But I would submit then the point is that why should we be too detained with parsing each line of the SCA judgment? We know that appeals are against orders and not the reasoning in judgment. Obviously, we can't ignore the reasoning.
Refer to we, who are you referring to when you say we shouldn't be too detained with going through the judgment line by line? Who are you referring to, Mr.
I'm saying
Chairman?
as an academic, I'm saying as an analytical exercise. I'm saying, one, the parties, but I'm saying as an interpretive or as an analytical process, the reasoning is not as important as the order. Because this court could say, we are not satisfied or we would not adopt the reasoning of the SCA, but we still have the power under Section 172 to make a just and equitable order, and we're going to make it on different considerations, or on similar considerations, but framed differently, or expressed differently, or analyzed differently. The point I'm simply trying to make is that this court has a self-standing power to make a just and equitable order. If the court decides that the order that the respondents are proposing is not just and equitable, of course it won't make such an order. I'm just simply arguing that respectfully, I'm submitting that the proper approach to a case like this for this court to adopt is rather to focus on what is just and equitable on the facts on the record, based in the context of what the merits finding was, etc. Because I can't defend the SCA judgment line by line with respect. The questions you're asking me, Justice Turan, are perfectly reasonable. But I'm simply saying that surely with respect, if this court has the power anyway to make a just and equitable order, perhaps the more important question is to ask whether an order along the lines of the SCA order is just and equitable.
You seem to be disparaging about some of the questions that the bench is posing, Mr.
Not at all, Justice Turan. No, not at all, Justice Turan. I'm just trying.
In your protected time, you also made some comment about you don't mean to be disparaging about the questions from the bench.
Justice Turan, if I said that and if it sounded like I was being disparaging, it was a verbal tick. It was not intended. I'm just simply saying that my respectful submission is that one doesn't have to be detained by the reasoning of the SCA, because this court does still have its self-standing power. But I do submit that if one reads the whole judgment, it has to be implicit in it that the SCA thought that it was balancing everybody's interests, because it had already very stridently said that the appellants had a right to be consulted and that that right had been violated. So I would submit that if one reads paragraph 31 of the SCA judgment, that's what it had in mind. But I certainly don't, I think the questions about the SCA judgment with respect are not at all something I would disparage.
Shell says that, or it has undertaken not to act on the exploration right until the renewal application has been finalized. And I think in the submissions prepared on behalf of Impact, they go further and they say that the Supreme Court of Appeal order, in fact, prohibits further exploration. Do you share that view? Or is it necessary for this court to make an order to clarify what the position should be?
I don't mean disrespect to my learned friend for Impact. I don't see that from the SCA order. The SCA order, if one reads it literally, suspended the declaration of invalidity. If that is true, then in theory, the parties could act on the right, because as things stand, the right stays in force. But that's why Shell went on oath, and I think Impact and Fairness also went on oath to say they don't have, they're saying on oath that they won't do it until the renewal application is granted. But the court could go further and say, look, we can't take the affidavits into account only, we can actually make an interdict. We can actually make an order that says you can't do it. That would be fair, I expect.
Thank you, Mr. Friedman. Thank you, Chief Justice.
Mr. Bielefeld? You do confirm that you waived your protected time, so
Yes,
you can be
yes, I
asked
did,
questions right away.
Justice. May I just deal with something which was raised now in the debate between my learned friend Mr. Friedman and Justice Theron about the question of the third renewal. If one has regard to volume 21, right at the end on page 2285, well, it starts at 2284, there's an affidavit deposed to on behalf of the first to seventh respondents. And those are, of course, Sustaining the Wild Coast and the various individual organizations. And it's deposed to by Ms. Wycombe, I think. And on page 2285, there's reference to the directive from the SCA, the presiding judge, dealing with, I think we've dealt with it before, about the renewal, because the first two renewals had expired, what's the point, is it not a moot issue? And then it's dealt with, and then over on page 2286, where they say in paragraph 6, they seek leave to file the short affidavit in response to the affidavits filed by the other appellants to address the issue raised in the court. In other words, the question of the third renewal. Then they go on to deal with various paragraphs in the Act, and perhaps of some significance is what is then deposed to at the end of the affidavit on page 2289, where the following submission is made. It says that, given the material and adverse effect of the possible renewal of the rights of the first to seventh respondents, as well as to the general public, any decision on the renewal application ought to be preceded by a meaningful consultation process. So I don't think it's quite correct to say that the issue of a renewal was not dealt with in evidence, because that evidence was before the SCA, and the applicants in this case chose to deal with it in that manner. Then perhaps a second general issue is the question or the suggestion that Section 172, I know the suggestion is, or the submission is quite correctly made, that Section 172 was not raised in the court a quo by anybody, and I'll just come back to that briefly. And Section 172, of course, was expressly raised in the SCA, and we'll find that in volume 24 on page 308 and 309, as well as volume 26 on page 2289, 5.504 to 507. So it was expressly raised. And what was further raised, if one perhaps has a look at volume 24, and this is the affidavit deposed on behalf of the Minister. It's on page 2289.308. There's the heading, non-consideration of a just and equitable remedy, and it deals with the usual submissions of what the law says about a just and equitable remedy, and it deals in paragraph 75 on 309 with the length of the time that has elapsed, planning, etc., etc. And then in 76, the following submission is made. We submit that it was entirely within the High Court's power to direct that a further public participation process be conducted to cure the perceived defects. So it's not as if this issue was not generically raised. I accept that the argument of a suspension order was raised by me during oral argument in the SCA when I referred the SCA to the Joubert, Gilpin and Searle decision, but it's in a sense in line with the general general argument. Then, as I think an important issue is the question of Section 51 and whether it's competent in a just and equitable remedy to allow a process which goes outside that. Now, in the original application, the applicants there and the appellants here argued quite vociferously that a box-ticking exercise is not sufficient. They said that even if you ticked all the boxes, you have to go further. And in fact, what they argued really was what my other colleagues for the respondents argued, is that Section 6 of the Act imposes an obligation which goes further than Section 81, which deals with PAJA and to take into account other constitutional issues. But on a practical level, the Minister's position is this. I am quite happy to entertain an application and to have a look at it and decide whether a case has been made out or not, which goes further than an application, strictly speaking, in terms of Section 81. I'm quite happy to accept that I will apply standards that should have been applied at the initial even the portion that I've read from the appellants, the one affidavit from sustaining the Wild Coast. Nobody's really averse to a situation where there is a process of further consultation. And yes, I think the SCA perhaps didn't formulate properly what it intended, but I think the gist of what they wanted to do was simply to say that the consultation process is flawed. I'm giving you the opportunity in terms of determination, in terms of 172, to cure the defect and to undertake a comprehensive consultation and evaluation. And my submission is that if the renewal is granted and the consultation process is unimpeachable, the exploration rights that were in place remain as a fact, and that the registration of those prior rights also remain as a fact, and therefore the renewal is based on a fact, albeit the declaration done by the court a quo. I've listened to the interaction, particularly between Justice Savage and Justice Rogers, and I think there's much to be recommended for the suggestion. There are obviously slight differences. Justice Savage had in mind a situation, as I understand it, is to go back in terms of an order by this court, to go back and evaluate in terms of what you should have evaluated in the first, and give directions as to the manner in which it should be done. Justice Rogers perhaps narrowed that down, which I think is a good suggestion, is to say that the minister must be ordered to undertake the renewal process and take into account everything he should have taken into account and what is expected to be taken into account in an initial application for such a license. Barring that, the SCA, if one has regard to the judgment, if I may just get the judgment. There was a lot of debate regarding paragraph 31 of the judgment, which appears in volume 22 at 2289.57. I think one should also read paragraph 31 in conjunction with what the SCA says in paragraphs 28 and 29, because one must read the three of them together. In 28 deals with the question that the High Court did not weigh up any relevant factors, etc., etc. It talks about the lapse of the expiry of time and in paragraph 29 it goes further. So that brings me on the general issues which I'm going to deal with, except for questions, just on the question that was raised by my learned friends for the applicants. The question of 172, the statement that it was never raised by the respondents in the court a quo, and my learned friend Mr. Ferreira on 2 occasions used the word they had the onus. Now, my respectful submission is 172 doesn't create an onus upon a litigant. 172, if one reads OPE, it is an obligation of the court to take into account factors to ameliorate a declaration of invalidity. In the Joubert, Gilpin and Searle case, in paragraph 93, there's the short quotation by Justice Fruneman, which succinctly sets it out. He simply says, once a ground of review under PAJA has been established, there is no room for shying away from section 172(1)(a) of the Constitution, which requires the decision to be declared unlawful. The consequences of the declaration of unlawfulness must then be dealt with in a just and equitable order in terms of 172(1)(b), and then also talks about PAJA, section 8. It gives detailed legislative content. So, one can't simply say that there was an onus in the true sense as we understand in litigation on the respondent litigations to raise that issue. It was an issue that should have been taken into account by the court. Perhaps I can use, by way of analogy, an example. If I don't plead prescription, as I understand the Act as it stands at the moment, the court doesn't raise it, it's got to be pleaded. But if from the pleadings or from the evidence that is led before court, it becomes apparent that there is a breach of the public mores or public policy, the court is entitled of its own accord, without it being raised in pleadings, to deal with it. And I would submit that similar as this, the court a quo should have dealt with it. I accept it's correct that the renewal application was made after the court a quo. The renewal application was, of course, made after the judgment in the court a quo, but subsequent to the lodging of an application or the lodging of the appeal, which of course suspended the order because the appeal had been noted. But I would submit to you, justices, that to go back now and to say what would the court a quo have done if it had known of this, which it didn't, the fact remains they didn't have regard to anything. So one must perhaps skip that process and go straight to the SCA, and that's what the SCA had in front of it. Barring those submissions and barring questions posed to me, that is the submissions which I wish to make on behalf of the Minister.
There are no questions for you.
Thank you,
Thank
Justices
you.
and Justices.
Reply, Mr. Ngquaitobi.
Thank you, Chief Justice. I would like to start with this issue of knowledge on the part of impact, knowledge of my clients and their interests. And also just to show the court where this appears in the various parts of the record. The first one is in volume 3 at page 246, which is the EMPR itself. In the third bullet point, it records, and this is dated the 26th of June 2013, it records the East Coast, particularly the Transkei coastal area, is home to a large poor rural community that is directly reliant on the coast/marine resources to supplement their livelihoods. So they themselves know about them. But then in addition to that, in the minutes, in the minutes of the consultation that was held with the chiefs, and that is at page 2690, and it's supplementary volume 4. One of the questions that are asked is this issue of how to present the EMPR to the community. Now, they are sitting with the chiefs in the meeting on the 16th of June 2013, and the chiefs respond as follows. ERM is best placed to present the technical information to the community. The monarchs would prefer a member of the project team to be available to attend any further meetings. And then you have finally the judgment of the the judgment of the High Court, which is at volume 22, page 2289, paragraph point 85, at paragraph 90 and paragraph 92. And where the High Court concluded this topic was to say, look, what they had in mind was that it would be enough if they spoke only to the monarchs. But they can't say that they were not aware of these interests. But quite apart from the record, it's just common sense. You know, we know for a long time, a lot of people, thought South Africa was res nullius. No one lives there. It's the same argument that along the coast, this big area, 250 kilometers, 42,000 square kilometers in total that you will be exploring, to actually have this mindset that nobody lives there, it's just outrageous. So that's the first thing on knowledge. So there was direct knowledge. And once there was direct knowledge, then it was intentional that they didn't consult with them, because their view was that let them speak only with the chiefs. That takes us back then to Bengwenyama. In Bengwenyama, it's clear in paragraph 87. If you know of the people and the interests that they represent and you elect not to consult, don't come to court later and say, I've spent a lot of money, because it's a self-inflicted injury. And then the second thing I just want to address is, I think it's Mr. Friedman. If you actually listen carefully to what he is saying, he says, listen, don't worry about this issue of the consultation. Just ask yourself whether or not the process dictated upon by the SCA is capable of influencing the decision of the minister. But influencing the decision in what? In the Section 81 process. You know what this is? It's really a scenario in which you look at the outcome. This is a case about process, not outcome. What my clients get is that their dignity is affirmed by participation in the process, even if their views are dismissed, It's the participation in the process. Now that's what Bengwenyama affirms, is that the dignity derives from participating in the process because it impacts on your rights and interests, regardless of what the outcome is. So I'm afraid you can't start from where Mr. Friedman wants to start, which is at outcome. You have to start at process, which is they want to be in the room, and they want to speak when they are in the room. Now the question, and now this is the third point, comes back then to Justice Rogers' point, which is there a way of getting this at a Section 89 process? It is just impossible to see how a meaningful process could commence at the renewal. It's just impossible. A meaningful process can only commence at Section 79. At Section 81, everything that had to be decided in Section 79 is already cast in iron. It's fixed, it cannot be changed. Why? Because the subject of the consultation, which is the exploration right, has been granted. What we are evaluating in Section 89 is whether or not it should be extended. What my clients want an opportunity for is to influence whether or not the right ought to be granted in the first instance. They have been foreclosed from making that submission by the order of the Supreme Court of Appeal. I listened to all of my learned friends, Mr. Friedman, Mr. Bielefeld, and Mr. Loxton. No one can get away from the problem that the right to influence the granting under Section 79 has been foreclosed permanently. Then I want to make the fourth point, which is what is the correct remedy right now in this point in time? Justice Savage, the correct remedy is what I think you were postulating. I understand you are not making suggestions, you were asking a question. So the answer to your question is that the correct remedy is that if the matter is to be remitted, to be dealt with under Section 79, subsection 4, subsection A and B. Now, Justice Rogers, they say, no, we have a problem with that because we lose the exclusivity. The fact is they don't have to lose the exclusivity because if you look at the actual text of Section 79.4, it starts with the words, if the agency has accepted the application, then it must do the following. There is no need to disrupt the acceptance of the application because the exclusivity derives from the acceptance because the Act says you cannot accept another application where you've already accepted one. So they already are guaranteed of their exclusivity. What this argument has really been about is how can they avoid consulting with my clients? That's really what we've been debating the whole afternoon. Now, regrettably, this has been the same mindset since 2013. They've been trying to avoid my clients. And if you try and look at the affidavit that was filed, I know, Mr. Loxton, you didn't sign that affidavit. It was your predecessor, so this is not a personal attack. But the affidavit is dripping with sarcasm. The affidavit filed by Impact. It's truly, truly a sarcastic affidavit. And the reason they took that attitude is because they never appreciated the actual need for my clients to have a say in the debate about their lives. Let's be fair about it. That's really what's going on. Now they've come to the Constitutional Court to try and get an endorsement of this sarcastic attitude they adopted against my clients. My clients don't want anything radical. You know, the clients of Mr. Ferreira have got an ideological position against a particular form of a source of energy. My clients don't have that at all. They don't care whether you use coal or you use anything. What they are worried about is that this is our land. And we want to be consulted about our livelihood. And so to try and club them together with non-governmental organizations is actually an unfair characterization. Because I don't act for an NGO, I act for a community. And that's why then we say, actually, the only way forward in this case is that Shell must be told to do what it refused to do in 2013. And that actually is correct because it's a lesson for others in the future that if you write roughshod over community interest, at a certain point, the judges of the Constitutional Court are going to tell you to go backwards. And this whole thing about, well, let's do it under Section 89 is actually an outrageous proposition. And Section 81 is an outrageous proposition. Let me explain why it's an outrage. No one in the industry believes that a renewal is a place to consult. I thank you.
You may finish off, Mr.
Yes. No one in the industry believes that a renewal stage is a place to consult. Everybody accepts that the place to consult is the initial application, and a renewal is a bureaucratic process that only connects the department with the holder of a right. And that's why the beginning of Section 81 assumes that you are already a holder of a valid right. Thank you, Chief Justice.
I could give you a minute or more. You did have how many opponents?
Yes, thank you. Let me take
Just
that.
a couple or more.
Yes, let me take that minute. Now, so to complete then the point I'm making, if you look at the text of Section 79.4, it says if the agency accepts. So what that means is that that remedy doesn't preclude your exclusivity. You already have that exclusivity. So that point, to clarify that. Then again, to respond to Mr. Loxton about the Supreme Court of Appeal, this is now point number 5. It is common cause that in the Supreme Court of Appeal, there was no debate about a suspension. No debate about a suspension. The only debate that was held in the Supreme Court of Appeal was a debate about mootness. Now, why is this an important point? The default position in an administrative law context is that you remit. If you want a different remedy, you then bear the onus to show why that remedy should be granted. It is equivalent in the context of constitutional declarations of invalidity to the default position being retrospectivity. And the case law in this court is clear that if you want a departure from the principle of retrospectivity, you must produce the facts that would substantiate and justify a departure from the default position. Nothing changes just because you are in an administrative context. If you want a departure from the ordinary rule, then produce the facts. Here, they never asked for the suspension. They could never have asked for the suspension pending a determination of the third renewal, because it did not exist. In fact, in the High Court, they did not ask for the suspension at all. I wanted to see Mr. Friedman saying, well, it was raised. Well, the reason he can't show us in the record where they asked for the suspension is because it's not there. The same thing I wanted to wait and see if Mr. Loxton will show us, but he also can't show us. In the Supreme Court of Appeal, that problem was exacerbated because we were debating one issue, which is the issue of mootness, and then we found an outcome, which was an outcome about suspension. But the principal point on the suspension is that because the suspension is tied up with the rule of law and the respect of judicial orders, it must be expressly debated, and that never happened. Thank you, Chief Justice.
Thank you, Mr. Itobi. Mr. Ferreira?
Sorry, can I just...
Oh, sorry.
It doesn't really arise from your reply, but it has just struck me, and I'm not sure if it's been clarified anywhere. There appears to be a missing word in the official version of Section 181, 3A.
Section 81.
81, 3A. That's the provision which says the Minister must grant the renewal. And it says, if the application complies and the holder of the exploration right has complied with A, terms and conditions of the exploration right is not in contravention. It doesn't make grammatical sense. And a similar formulation appears in several other instances for other types of renewals, and the word "and" appears between right and is. And perhaps before...
Yes,
Mr. Ferreira finally closed, the parties can just agree that we should read "and" between right and is.
Yes, that is what I noticed when I was reading to the court initially, and then I thought it was just me. It turns out there are two of us. But it's clear that there's a problem there. There's a whizzing mad right.
Yes, I noticed the same formulation, but with the "and" present was in section 18.3a and 24.3a.
Yes, that must be so, because the first part is whether you've complied with the terms and conditions of the exploration, and terms and conditions of the right, and is not in
Has
contravention.
complied and is not.
And is not in contravention. So I think that's correct, but I haven't got the original. This is the Safely version of the...
Yes, I'm looking at the original, the Government Gazette, when the original version of the Act was promulgated.
Well, this is the Minister's Council. He must know.
And I see, by the way, that parties have quoted it incorrectly, exactly, but ungrammatically in their affidavits and submissions.
No, the problem persists. I'm afraid I can't help. Yeah. Thank you, Justice Rogers.
Mr. Ngogaito. We appeal. There is a formulation that was prepared by my brother Rogers, and it says, I read it out aloud, the minister shall refuse the renewal if on the information before him he would have refused to grant an exploration right. What is your response to that? In particular, I just want your response on if on the information before him. I just want to know, when is that information? Is it at the 79 or 81?
But after the consultation process that has been ordered by the SCA.
Oh, okay.
I think someone has been corrected.
He's corrected me. It said after the consultation process has been ordered by the SCA.
Yes, but your question still remains, Justice Matopo. Which consultation process? A Section 79 process or a Section 81 process? Because if it is a Section 81 process, it suffers from these defects. One, it suffers from a separation of powers problem, because the court is literally just legislating using its power under Section 172, and it's legislating in a manner that's not contemplated in the legislation, because the legislation is clear when it wishes to deal with consultation. Section 79, 4A and B are explicit. If the legislature had intended to import similar provisions to Section 81, it would have done that. That's the first problem. The second problem is why? What is the justice and equity that the court is trying to achieve? Because the court can achieve a perfectly just and equitable outcome by ordering a consultation under Section 79. And there it only needs to temper with the order of the SCA in a very narrow way, by simply guaranteeing Shell that its application shall remain accepted. And that's the point that I was debating earlier with Justice Savage, that if the application is accepted and the entire Section 79, subsection 4A and B process is rerun, then that is a perfectly legitimate outcome which does not do any violence to the scheme of the legislation.
Counsel for the Minister offered a proposition that the Minister will apply the same standard that should have been applied in the initial stages. What is your understanding?
Well, I hope the client has a different view to the advocate, because if they did that, it's just an invitation to a review, because they can't apply the same standard because the statute requires them to apply their minds to different considerations. In the first Section 79, you are deciding whether to grant the right at all. In the Section 81 process, you are deciding whether to extend, and there's a closed list of factors, which regrettably in paragraph 31 of the SCA has been expanded, but it's been expanded in a very unwieldy fashion. So it's impossible on the statute to do what he's suggesting. So I'm hoping that his client will follow the act.
Thank you. Thank you.
All right. Thank you, Chief Justice.
Justice Rogers, to start with the easiest question, I understand that Juters has actually inserted the missing and in square brackets under section 81, and I understand as well that Professor Dale addresses the question of that missing and explains that in fact there is an and missing precisely where you identify the lacuna. Chief Justice, if I may address my points in reply under two separate headings. Firstly, the question of what I called in my main address our first prize, which is that the High Court order we submit with respect should be revived. I won't belabor this point, but what we submit is that section 172(1)(b) of the Constitution does give this court extraordinarily wide powers, as has been held in Mhlope and other cases. But our submission is that exercising that power goes too far when it is done in the absence of any facts justifying its exercise in that direction. And we submit that when courts exercise judicial discretion in a vacuum, absent properly pleaded facts to sustain that exercise, there are fundamental difficulties that arise for the rule of law and for legal certainty, because it becomes impossible to predict as a litigant and as a legal advisor what courts are going to do when in public law cases. And this court has held, for example, in the Aba case, that predictability of court proceedings, a reasonable degree of predictability, is an element of the rule of law. What this court held is that in the context of respecting precedents, is that precedents must be respected in order to ensure legal certainty and equality before the law. This is essential for the rule of law. Law cannot rule unless it is reasonably predictable. Now, justices, if one can come to court and find that no case has ever been pleaded for a suspension plus a new consultation case tacked onto a Section 81 renewal decision, but you can be hit on the head with it at the end of the day, at an end of an appeal, we say that that is an example of where justice and equity has gone too far and where the rule of law is undermined by a free-floating discretion which is unconstrained by facts and unconstrained by pleadings. And if I may just give you one example of the kind of fact that should have been pleaded and could have been pleaded, is we talk about this moratorium as one of the most important factors in favor of the court exercising its discretion in favor of not setting aside. That moratorium enters the record by way of judicial notice, if my memory serves me correctly, for the first time in the application for leave to appeal in the High Court, never pleaded, never relied upon by any of the parties. If it had been put in the affidavits, the minister would have been able to explain what is the purpose of that moratorium, why have I imposed it, does it apply to this application, and explain why we should help Shell and Impact evade the import of that moratorium, if so, and we could have responded to those. And the same goes for all the other facts, justices, that are relied on in support of the remedial discretion. We say it should have been pleaded, it wasn't, and that is why it's not just and equitable to come to their aid. Justices, Mr. Friedman submitted that there was a hearing on remedy in the Supreme Court of Appeal, and he said, just look at Mr. Ferreira's heads. He had made a whole argument about remedy. With respect to Mr. Friedman, he was mistaken in that submission. The point that I and Mr. Tnukai Toby made here is that there were three fundamental elements of the SCA remedy that were never debated, put to us, or pleaded at any point before the order. It was, number one, the suspension. Number two, suspension pending a further consultation process. And number three, as part of a Section 81 renewal application. And Mr. Friedman, with respect to him, is simply mistaken when he submits to you that my heads of argument in the SCA dealt with those things, because they did not. If you want to look at those heads, justices, I wouldn't necessarily recommend it, but if you want to look, they're in the record at page 2289.311. only a part of the heads appear there, an extract from 79. In fact, the section dealing with remedy was from paragraph 71. But there was a chapter on just and equitable remedy, but the just and equitable remedy we were arguing about was the one that I referred you to when I argued in chief, which is where Impact and Shell said, the remedy that we ask for is that you simply let us act in terms of this unlawful right. And my heads of argument in the SCA explained why that was not just and equitable. And that was the basis on which I submitted, that we got hit on the head with this nasty surprise when the judgment came. Justices, if I may move on to our second prize, which is that if you are not with us, that the High Court order should simply be reinstated. We submit and we agree with Mr. Nkaitobi that what you have to do, the only possible thing that can remedy the wrong that was done here, is to go back to section 79 rather than section 81. And we ask rhetorically, if this court is going to read into section 81, essentially a section 79 process, which is what Justice Rogers' formulation provides for, then why are we even in section 81 instead of section 79? What's the benefit? We submit with respect that while Justice Rogers' proposed formulation is indeed elegant, we submit the more elegant order is simply to go back to section 79.4, and in addition, all of those provisions of the MPRDA regs, which explain to everyone who conducts a 79.4 process what has to be done, because that means you don't have to legislate for all of that from the bench. You don't have to write into section 81 that for this case only, section 81 is going to mean you must go and consult, and you must leave it an open question whether the right is going to be granted, and you must follow the Integrated Coastal Management Act. None of that is in section 81. There's no need for you to put it in there because it's all in the existing section 79.4, and the moratorium is not a problem because, as Mr. Nkaitobi submitted, we go back to the point in time when PASA accepted the application. PASA would then instruct the applicant to conduct its application process, and it would go from there. The deeper question, Justices, we submit, the court should ask itself, is why are Impact and Shell so keen to be in section 81 instead of section 79? Why are they so eager to be in section 81 instead of section 79? And the answer is obvious. Because they don't want to have to go through the onerous process that they would have had to go through if they had done this lawfully from the outset. And Mr. Loxton made that clear. He said, we've done huge work already. We don't want to have to replicate that work again. They don't want to have to go through the much easier section, the much more difficult section 79 process. But we submit it is not just and equitable to go back to 81, because 81 entitles our clients to less than what they would have been entitled to if a lawful process had been done from the outset. And that means that section 81 cannot vindicate the rights that were violated by the illegality in this case. Thank you, Chief Justice.
Okay. All right. Thank you very much, gentlemen and ladies. Judgment is reserved. For a chance.